I'd like to get your attention, please. Can everyone hear me okay, first of all? Raise your hand if it's not loud enough, or if I'm not holding this correctly, or I want to make sure that everyone can hear what's going to go on tonight. Good evening, and thank you for attending our informational meeting tonight. My name is Corey Firstenoff, and I live in rural Neligh and farm, our family farm with my father and grandfather. I'd like to introduce Dean Smith, if he can stand up. Dean also farms in rural Antelope County. And I'd like to introduce Mark Hunziker. He's an attorney with Baylor Evman Law Firm in Lincoln. His expertise is in land use. We're going to present, someone you can't see right now, we're going to be video conferencing our main speaker tonight, Kevin Martis. Kevin, are you there?
Yeah, I'm here. Can you hear me okay?
Let's see if we can turn you up. Okay, how about now, Kevin?
How's that sound? Can you hear me okay?
Yeah. Can everyone hear in the back of the room? Go ahead, speak, Kevin.
All right. How's everybody doing tonight? Can you hear me?
Yep. Okay. We're going to be going to Kevin here in a little while. He's our main speaker. Kevin is a former vice chairman of Regan Township Planning Commission and senior policy fellow, E&E Legal Institute. We're going to present information pertaining to our current Antelope County wind energy zoning regulations and how the current setbacks and standards affect home and landowners in the proposed wind energy project in Antelope County. We're also going to be presenting topics such as living with wind turbines. We're part of a group, Dean and I, called Protect Antelope County's Future. It's a group of residents living in Antelope County. Many people in our group currently reside in the proposed 168 wind turbine area. Is this speaker sound okay? Because to me it's kind of blurry. It's too loud. Okay. Is this better? Ollie? Is that better, Brian? Okay. Just want to make sure you can hear me. It's like yelling at my kids. They can't ever hear me. Our group, Protect Antelope County Future, formed as a result of many concerns that the current wind zoning regulations do not adequately protect the property rights, health, and safety of Antelope County residents. That's about all that I have for now. We're going to lead into Kevin's presentation, and as you watch and listen to Kevin's presentation, I ask you to ask yourself a question. How close would you like to live to a wind turbine? You can go ahead, Kevin. I don't know if you want to show everyone your face so we do know that you are real.
Yeah, I'll do that. You may want to shield the eyes of small children. Let me see if I can make this thing go here. Can everybody see me now? Good. I don't hear you guys very well, and if you have any trouble hearing whatsoever, please let Corey know, because it's important that you be able to hear what I have to say. It's a pleasure to be with you tonight. I live in a very small community, maybe somewhat like yours. Our township of Riga, Michigan, has about 1,100 people, which I know is a little more than you'd have in your townships, but we're number one in corn and number two in soybeans in our state almost every year. And so that's the kind of community we live in. I'm a graduate of the University of Michigan. I know that doesn't get me much in Nebraska. I get an even colder reception in Columbus, Ohio. I guess that's the best I can tell you. And Corey told me not to bring up 1997, so I'm not going to. We'll leave that behind us for those of you who are Husker fans, which I assume is virtually everybody there. I'll try not to be too boring. I typically say that talking about wind energy issues is like wetting your pants in a dark suit. It gives you a warm feeling nobody else notices, but over video conference you wouldn't be able to tell one way or another. But I'll try and be good. Well, I'm going to go back to my presentation now. And you know, your community is facing maybe one of its most important land use decisions ever. I've seen this take place many times in Michigan and across the Midwest. And the decisions your county's making will be with you for generations, for the next 40, 60, maybe 80 years. So it's important that you take the time to really understand what's involved with the scope and scale of the project as proposed by Invenergy. So I'm going to share with you my experience as I've been working with these issues since 2009. Now I'll start my program here. Is everybody able to hear okay?
Is it okay in the back of the room? Not blaring?
Okay, I'm going to proceed, and if you need to adjust the sound or something, please interrupt me and we'll sort that out. So I won't belabor this too much, but I did work in ag land preservation in our county. And one of the ordinances that we created in my own township was later added to a list of state model wind ordinances. Since 2011, I've lectured on equitable wind energy zoning from Michigan to Kentucky and as far west as North Dakota. The ordinance recommendations I make have been adopted in many ordinances. You can see the bottom line is the list of all the model ordinances the state of Michigan assembled, and I was proud when ours was added to the list. Some of these ordinances are very permissive or wind friendly, others are very restrictive. By the way, I'm not a lawyer, but I do watch Law and Order. Nothing I say should be construed as offering legal counsel. Developing wind energy ordinances that can withstand legal scrutiny is a specialty, and it is important to retain experienced counsel in these matters, and I trust that your county has done that. And if there's any elected or appointed officials there who are involved in these land use policy decisions tonight, I would say I was a former planning commissioner. For 6.5 years, I worked on land use issues. Nothing was more difficult for us in our community than the question of whether or not to turn our township into essentially what is a 50-story tall power plant. And that's a thankless task that when you take a job like a county commissioner, supervisor, or a land use expert or policymaker, you don't really expect to have these types of things thrust on you. And because wind energy covers such a broad area, and because the devices themselves are so tall, it's very unique among land uses. The good news is I believe that reasonable wind energy zoning regulations driven by two principles, consent and compensation, can place the burden of deciding whether a given community hosts utility scale wind development upon the wind developer rather than the zoning authority. I know that's a little murky right now. As my presentation continues, it'll start to make more sense. But I think that's the way it should work. So as I said, Michigan has 1,500 megawatts of wind turbines installed right now. It's about twice what you have in Nebraska. Initially, the state issued some guidelines that were not binding, recommending 1,000-foot setbacks from home and a 55 decibel noise limit. It became an informal standard that the wind developers often proposed as a reasonable regulation. In fact, that's what they brought to my township. But since 2008, experience has been a harsh teacher. Every major wind development in Michigan has produced widespread complaints or legal and political action regarding wind turbine impacts. I live down in the very bottom of this map with a cluster of 4 black dots there. I live in that county right there. It's called Neligh County. But I'm going to talk just briefly about the county called Delta County where the red star is. That's called the Garden Peninsula. They only built 14 turbines there, and they're about 400-foot class turbines. Yet 73 people living inside that turbine cluster have signed petitions asking the county to stop the noise. That's a pretty high ratio. In fact, it's a worst case in Michigan. But these folks live 1,500 feet up to a quarter mile or a half mile from the wind turbines, and the noise has become very problematic for them. Consider Sanilac County. You may or may not know that the production tax credit for wind energy was just extended this last December in the omnibus budget bill. And suddenly the wind rush is on. Wind developers really are desperate to have that subsidy, and when it expires, development really falls off. Well, this is Sanilac County, Michigan, along Lake Huron, and you see all those townships right now are in extensive battles with wind developers, because in Minden and Delaware, at the top of the map, they can already see what wind development looks like. And that they have seen what those communities have come and become, and it makes it much harder for wind developers to move forward with their projects. Now in Michigan, we still have township level zoning. And so Invenergy, in fact, has been trying for the last few years to build in several of these townships: Argyle, Wheatland, Moore, and Lamont. And Exelon is working in Marion, Bridgehampton, and Washington. The three of the four Argyle Invenergy townships have placed this permissive wind zoning on the ballot, and they were successful in turning down permissive wind energy zoning regulations. And in Michigan, whenever a township has voted on wind energy regulations that are friendly to the wind developer, they have turned them down every time by almost 2 to 1. The closest was in Seneca, 51 to 49. But in that small township, the president of the wind development company, his son was the township supervisor. But even then, it wasn't enough to get them over the finish line at the ballot box. And in, let me see, Moore Township last fall, Invenergy spent about $160,000 on public relations trying to win that election. In just a 36 square mile township, they spent that much money, but nonetheless, the people still said no. Curiously, what's happened over time, this is Huron County at the tip of the thumb. There's more wind development in Huron County than the rest of the state of Michigan combined. In fact, they have roughly half as many turbines in that one county as you have across your entire state. They have a lot of experience with wind and have been at the leading edge of it since 2007. But Huron County residents appear to have had enough. Detroit Edison, which is one of our large monopoly utilities, now curiously faces a leaseholder revolt. This is the first time we've seen this. In Lincoln Township, Detroit Edison wants to build more turbines there. And all 5 of those township trustees have wind leases. They stand to profit significantly if this project gets built. Nevertheless, they sent a letter to Huron County zoning, under whom they're under their authority because they did not adopt their own zoning regulations. They sent a letter to Huron County saying, we feel that Huron County has done our part as far as green energy. We feel that no additional turbines should be allowed in Huron County. So that's the voice of people who stand to profit, who have leases signed, and nonetheless, they've looked around their county and see what it's become with 350 turbines and 200 more on the way, and they said, you know what, we've just flat out done enough. So now I'm going to talk about a couple things that are sometimes used as a way to convince communities to move ahead with wind development. And one of the more popular ones is to say, well, look, the Obama administration has passed this Clean Power Plan, and we have to reduce carbon dioxide emissions. Well, our grid operator, MISO, analyzed the Clean Power Plan, and I just want to draw your attention to the box that's circled where it says $237. That's the price per ton of CO2 avoided by building wind turbines. You notice compared to the other ones, it's by far the most expensive. And in fact, the presentation goes on to point out that it's far cheaper to reduce CO2, if that's one of your main concerns, is by building gas turbine plants, which Invenergy also happens to build. They reduce CO2 for about $38 a ton. So wind is a very, very expensive way to reduce CO2 emissions. And Invenergy confirms that. This is one of their gas plants, and they really do a great job with combined cycle gas turbine plants. But they said on the right there, every megawatt of power generated by an Invenergy natural gas fuel plant produces 45% less CO2 than would a coal-fired plant of similar scale. And a hometown favorite, Warren Buffett says, for example, on wind energy, we get a tax credit if we build a lot of wind farms. That's the only reason to build them. They don't make sense without the tax credit. And Warren Buffett happens to be very concerned about global warming. Now, what about land use? This is your Cooper nuclear plant down on the Missouri River there, and it makes about 800 megawatts of dispatchable baseload energy with 0 emissions. If we wanted to build enough wind turbines in your county to replace the annual output of that nuclear power plant, you can see how much land we'd have to cover, about 400 square miles. with the wind turbines like those proposed, assuming 2 turbines per square mile and assuming a 50% capacity factor. But curiously, because the wind often does not blow at times of high demand, it tends to blow more often at night rather than the day, and in July and August, wind's output drops a whole bunch. You would still have to build 800 megawatts of gas turbine plants, which curiously fit on a very small footprint. This gas plant would probably fit on a quarter section or a half section instead of covering 400 square miles with wind. So wind has one really substantial issue. It requires an awful lot of land. If you look at it from a township level perspective, 36 square miles of wind turbines, like those proposed for your community, will produce the same amount of energy as a couple of these small semi-trailer mounted gas turbines that you can hide inside your average dairy barn. So now I'm going to go back to proper zoning issues. So we have a proposal in front of us. How do we evaluate any product that is brought before us? Well, we all as consumers, be us a farmer or a homemaker, or like me, I'm a general contractor, we look at the total cost of ownership. To establish an accurate total cost of ownership, we first need to know the price and then evaluate the benefits and costs, which is easy if you're going to buy a new car. We all know about cars. In your community like mine, we often all know about tractors and so forth. And so we have all these familiar things that we look for. We have brand loyalty. Some love Chrysler, some hate Chrysler, some are Buick fans, some like foreign cars. But nonetheless, we know a lot about these things because we're very familiar with them, and we make our decisions based on past experience. But many of us don't have much experience with wind. Now, you do have one development in your county. I don't know how much of you spent much time there, but when a wind developer shows up and says he would like to build some 100-meter class Vestas V100 turbines like they did in my community, we now have to ask some questions about unfamiliar products. And the first is, well, how tall are they? Curiously, my developer didn't want to tell us how tall they are. We didn't discover it until we got it off the FAA's sighting website. Anyways, V100s are 476 feet tall. Well, how big is that? Well, my friend in Mason County, Michigan, over on the Lake Michigan shoreline found out. This is the turbine that's 476 feet from his home at 1,139-foot setback. The newest turbines, by the way, are now 670 feet. My friend ultimately sold his house at a 35% loss. He could not continue to live there due to the noise. In fact, it broke my heart. About 2 years ago, his 2 sons were off at college. And I hate to say where, because it's Michigan State. But nonetheless, they were at Michigan State and came home for spring break. They'd been away for a number of months. And when they got in the house and tried to sleep that night, they said, "Mom and Dad, we've forgotten exactly how hard it is to sleep here now." So they've ultimately sold the house at a substantial loss and have built a new one several miles outside the turbine project. And so the 660-foot turbines now are actually taller than the tallest building in the state of Nebraska. Those are coming to Ohio now, and I don't know how quickly they'll come to Nebraska, but it's important to remember that your land use regulations are not designed just for this Invenergy project. Those are regulations that apply to the entire county, and they apply to every developer. Now, you do have a conditional use process where you can apply some additional changes, but it's important to not fall into the trap of thinking that this ordinance is really just a negotiation with one particular developer. Your ordinance opens your county up and has opened your county up to development by anybody who wants to apply. And you don't know which turbines and how, whether they're a reputable developer or not. And here's what 494-foot turbines look like in Michigan, up in the tip of what we call the thumb in Lake Huron. I took these pictures this spring. And this is out in Ocotillo. The thing that people find most objectionable, curiously, out of all the wind developments I visited, the thing that almost everybody despises, whether they have a wind lease or not, is the flashing red lights. They generally all blink in unison. And when I was in Huron County a few years ago, I was up north of a town called Elkton, and we stepped out at night, and way to the east, I could see flashing red lights over there. And I said, "Are those the turbines in Ubly?" And my friend said, "Yes." And I said, "What is that, 10 or 15 miles? No, 38 miles. 38 miles distant." When I was in Huron County this last month, I was there at night, and it's unbelievable what several hundred flashing red lights look like. There's a tremendous change in your night skies. And this is in DeKalb County, Illinois. This is a NextEra project, and those turbines are 390 footers. And this picture is taken of the Hulteen home. They later got involved in litigation with NextEra. She said when the turbines first came on, she was upstairs in her home, and she thought somebody had put some tennis shoes in the dryer. And she kept looking for the source of the noise, and it turned out that the turbines had just begun operating. So these 390 footers, this is the night, and that's measured to the tip of the rotor. This gives you an idea of what the perspective is like as you look across the field of their house at the various setback distances. As you can see, there's not a tremendous difference in perspective at 1,400 feet versus 2,100. It's my understanding your ordinance permits 2,000 feet to non-participating homes and 1,000 feet to participating. So now let's think about what are the principles that we have to use to guide our land use policy. Well, this is a quote from your zoning ordinance, and it's very similar to what people use all across the country. Your ordinance says this resolution is enacted for the purpose of promoting the health, safety, morals, convenience, order, prosperity, and welfare of the present and future inhabitants of Antelope County, present and future. Now, for my purposes, I'm going to lump morals, convenience, order, and prosperity under the term welfare, because it's just cumbersome to repeat all those words again and again. Most ordinances usually say health, safety, and welfare. So my point is, put another way, and this is a guiding principle for me, if the proposed activity cannot be performed in our communities in keeping with health, safety, and welfare, it must not be permitted. Remember, any kind of developer that comes to your community, their primary commitment is to their bottom line, and their recommendations are typically designed to maximize their return on investment. That only stands to reason. Your land policy folks, be they your supervisors, or I'm not sure if there's a planning board there, but the people who regulate your land use policy are there to protect your health, safety, and welfare. So what are the limits to zoning? What can you do with zoning and what can you not do? Now, maybe Mr. Hunsaker will expand on this a little bit, and I'm not a lawyer, but in general, zoning regulations across the country must have a rational relationship to protecting health, safety, and welfare. They must not be arbitrary or capricious, which would be like saying only Methodists can live in this section of the county and only Presbyterians can live over there. That's arbitrary and capricious. If you pass those two tests, your zoning regulations are almost unassailable in court. My point is, reasonable zoning is very, very strong in the eyes of the court. It has a presumption of validity if you didn't stumble over these criteria. Protecting health, safety, and welfare is a sworn duty. Developers are crafty and present many superficially enticing arguments and promises, but health, safety, and welfare comes first. So a few quick questions. Are any developer's profits more important than health, safety, and welfare? Are promised increases in tax revenue more important than health, safety, and welfare? Are claims of private property rights more important than health, safety, and welfare? Are claims of green jobs or emissions reductions more important than health, safety, and welfare? Well, quickly, the answer is no, they are not. And remember, it's the health, safety, and welfare, not health, safety, or welfare, that land use regulators are duty-bound to protect. Too often, I see communities trade off health and safety in exchange for promises of tax revenue or green jobs and these kinds of things. But those promises made at these meetings are not contracts. In Huron County and in Tuscola County, up in Michigan's thumb again, all the wind developers showed up and said, we want to be good neighbors, and we're here talking about the taxes that we're going to pay to your community and so forth. As soon as the turbines were up in operation and the tax man came around to assess those turbines, they are now appealing those tax assessments turbine by turbine at the Michigan State Tax Tribunal, and those counties have had to hire lawyers jointly to challenge those valuations at the tax tribunal. I don't know how your turbines are taxed out there, but suddenly the good neighbor thing seems to fall apart a little bit as they have to do what's best for their shareholders. So there are many things involved with impacts associated with wind turbines and proximity to human homes. The most important are height, setbacks, and noise limits. Others may include aviation impacts like crop dusters and these kinds of things, radio frequency interference, or environmental impacts like birds and bats. You can talk about these things all night, but I'm going to focus only on a few: height, setbacks, decommissioning, property values, and noise. So, in general, communities are free to regulate the height of all structures simply on the basis of appearance, unless your state has preempted that. For instance, many zoning ordinances restrict homes to only 2 or 3 stories, even though 4 or 5-story homes can be built safely. Wind turbines are no different than any other lawful use. You may restrict their size for the sake of appearance. You don't have to prove a wind turbine is unsafe to simply restrict the height. You do that with other structures all the time, and nobody raises any questions. Consider billboards. This quote from this ordinance is from Stark County, North Dakota. It says, the purpose of regulating signs in the county is to provide for a visually pleasant environment and minimize potentially unsafe conditions while also offering opportunities for public and private information. Guess what? We regulate things on appearance all the time. We have that ability. Now, folks that do that sometimes are called NIMBYs, not in my backyard. But frankly, zoning ordinances give you the power to decide exactly what your backyard looks like. That's the entire purpose. And turbines have impacts too. This is another project up in the thumb. And listen to what this fellow said from Detroit Edison, who actually owns and operates these turbines, in a podcast that I found on a public radio station. He says, certainly there are some pristine places in Michigan where you don't want to impact the viewshed. You take a situation like Neligh County, the old Mission Peninsula here in our region. Curiously, it happens to be where this gentleman lives. Certainly there are areas where just while it would be perfect economic sense and perfect placement, we probably don't want them there as a region. Well, it's apparent that the community in which they did build them in this picture, they obviously did not consider pristine enough. But who gets to decide? So the question comes back to is how tall is too tall for the turbines in your community or for any structure? Just like any other land use, it's up to you. So now about the setbacks. Who do we trust? Well, I like to start for physical safety with the owner's manuals for these various turbines. Now, General Electric only addresses icing as far as a setback distance. They recommend, let me see, before parking near the turbine, if your turbine is frosted up, these instructions are for the operators and technicians who work on the turbines. So if you've had a frost event and the turbines have been stopped, then they tell you to stop at a little over 1,000 feet and check the rotor blades for ice by means of binoculars and the sound of the rotation of the blades. If the turbine is running and ice is present, call for a remote stop. So 1,100 feet is a safety zone for their employees in the event of ice on the turbines. Vestas is one of the biggest manufacturers of turbines in the world. They have a health and safety instruction that talks about what to do if the turbine has a brake failure and it spins too fast. And they say if a runaway operation should occur, the plant must be evacuated immediately by running upwind, and access to the surrounding area in a radius of at least 500 meters must be restricted. That's 1,640 feet. Now, when they routinely locate turbines only 1,000 feet from people's homes, if that home is directly upwind of the turbine and it's not leased to the wind turbine company, their technicians are supposed to run across that private property to get out of the danger zone. But I've never been told if they're obligated to knock on your door and to let you know that that's happening. It seems reasonable that that would be required at bare minimum. Nordex says the same thing. If there's a fire in the nacelle or on the rotor, parts may fall off. Again, if there's a fire, nobody's permitted within about 1,640 feet. So the manufacturers are pretty reliable sources of the distance at which these things can pose some physical risk to the neighboring landscape. So in real life, this we kind of snarkily say this turbine self-decommissioned. This was an overspeed event in DeKalb County, Illinois, and my friends on the ground measured the debris field at about 1,500 feet. That's only a 390-foot class turbine. It's smaller than the ones proposed for your area. My point is the developers have a pretty good idea of what the proper safety zone is when an event like this happens. And it is happening more often. One of our turbines in Huron County, similar class, but made by Vestas, exploded this winter. Same kind of thing. Brakes failed, and the rotor blades ultimately flex back and finally contact the tower, and that's usually what causes the damage. So, despite published safety data like that in these previous slides, wind developers still demand turbine setback distances ranging from 1,000 to 1,400 feet in Michigan from neighboring homes, leased or unleased. This is what I call trespass zoning. By demanding that the setback distances for wind turbines be measured from homes on adjacent properties rather than from the property line, which is typical of almost all other land use regulations. I see your ordinance actually has the first regulation I've ever seen that measures something from an interior feature of a neighboring parcel, and that's your separation for high-intensity animal feeding operations, which measures those distances to homes rather than property lines. I still think property lines is a much fairer way to do it. Yours is the first ordinance I've ever seen with anything like that. But nonetheless, virtually all other regulations are to the property line. You pay taxes up to the property line. We try and protect that property through zoning. We call this trespass zoning. When you reach across the neighbor's property with your setbacks, you are basically trespassing. If we understand trespassing is showing up somewhere where you were not invited. So what does that look like? Well, I made a little map here. It's not to scale. The guy on the left does not have a wind contract. The guy on the right does. So in Michigan, they recommend 1,320 feet to the home, even though the manufacturer's evacuation zone is 320 feet bigger. Well, the one thing we can do is we could back that turbine up so that at least the manufacturer's evacuation zone would not include the house. But you see that semicircle there that's on the no contract farmer's parcel. He's lost a lot of area that's now inside that evacuation zone. That's a place where his kids may have swing sets. It may be a place where he wants to build a second home for his son or daughter who's going to take over part of the family farm. The green no contract farmer has basically donated future development rights to the developer for free because it's measured from the home. The only proper and safe way to do this and to protect everybody's property rights is to measure those setbacks from the property line. Then the guy on the left can still develop his property completely, at least not be inside the safety perimeter. Here's an actual example of trespass zoning. I hope you have a clear view on the screen. This is an Exelon project in the thumb. The gray parcels in the middle are unleased, and the green parcels on the right and the left are leased to Exelon, and the circles show their setbacks. The orange circle, if you can see it clearly, those are the 1,320-foot safety perimeter, or setback distance. Now, if I zoom in on these parcels, you can see those orange lines take about 50% of that parcel in the middle away. They've placed most of that guy's property inside the setback distance without his consent and without compensation. Nearly 50% of his farm is now unbuildable. So what about your ordinance? Well, we have a 2,000-foot setback to neighboring dwelling units and only 1,000 feet for participating landowners. Well, the 1,000-foot number to a leaseholder is already hundreds of feet closer than major turbine manufacturers require for employee evacuation. So that would already give me pause. And although the 2,000-foot setback to non-participating homes is large enough for physical safety when measured to the house, you have such a small property line setback, just a little over 500 feet, that evacuation zone, that safety perimeter, may still intrude more than 1,000 feet into unleased neighboring farms. That doesn't seem reasonable to me. And we may want to think that 2,000-foot setback is better than the 1,500 and 1,000-foot asked for in Michigan. This home is in an Invenergy project in Illinois. And the turbine behind the home, that's my understanding, is at 1,600 feet. One across the street from him is at 2,200 feet. He abandoned this home. They tried to live in the home for 11 months after the turbines went into operation. The noise was so problematic that they could not sleep. They moved their beds into the middle of the house and all tried to sleep communally to get away from the noise. They were not successful. Invenergy shut the turbines off many, many times until finally they just left. They couldn't take it, and they bought another home. They still maintain this one, though this was the first he'd been back to see to the lawn. I'm not saying that happens to every house within 2,000 feet, but in probably 3 out of 4 major wind developments in Michigan, we have people living in a similar fashion, enduring similar effects. I can take you to a home in Huron County where the man is living in a concrete bunker that he's built in his house to avoid the noise that keeps them awake. Prior to that bunker, he kept an apartment in the neighboring village, and he would check the weather to see which way the wind was blowing. And when it came out of the southeast, they would go stay in their apartment in town because they knew it would be too noisy to sleep in their house. current Antelope ordinance makes the state of trespass zoning quite clear. It says the setback for dwelling units shall be reciprocal and that no dwelling unit shall be constructed within the same distance required for a commercial utility wind energy conversion system. What's that mean in plain English? If you build a turbine on a barren piece of farm ground and the setback circle goes 1,000 feet into the neighbor's parcel and there's nothing built there, you can no longer build inside that circle. In many communities, they claim that you can. But that doesn't seem to be true to me, and it's clearly not true in your case. It's my understanding that as part of the conditional use agreement in Venergy, it's offered to give people a waiver to build inside that setback distance, which makes me wonder if the setback really is based in health, safety, and welfare, because if it is, how is it waivable? But think about what that means. That means you can own a farm, and if your neighbor's tenant builds a wind turbine on it, you now have to go to your neighboring farmer's tenant and ask for permission to build on your own property. That strikes me as being fundamentally unjust. Now, we all love private property rights. I'm a free market guy. I think that private property rights are sacrosanct. But Oliver Wendell Holmes, the Supreme Court Justice, summed it up well. He said, "The right to swing my fist ends where the other man's nose begins." Our property rights should not cause harm to those next to us. My corollary says, if my development project requires me to repeatedly punch you in the nose, I should first get your consent and then at least compensate you for your broken nose. The express goal of zoning regulations is to separate conflicting land uses from each other. That's why we create zoning. But by establishing setbacks and noise limits from neighboring homes rather than property lines, the conflicted uses actually granted legal access to the neighboring property without consent or compensation. This is fundamentally unjust. So what is the right setback distance? I've talked about a lot of numbers here. Well, I would say for this present class of 500-foot turbines, it seems that a 1,640-foot setback would be a reasonable distance, for at least for physical safety, as measured to the property lines. But if you're regulating the setback distance to serve as a stand-in or a proxy for noise regulations, then distances up to 1.25 miles from unleased property lines are reasonable. And there's a good reason you may want to consider just using distance to regulate noise rather than noise ordinances themselves. I've seen what happens when counties try to enforce their noise ordinance. And when you try to enforce your noise ordinance, it's at your own expense. Your liability insurance policy does not cover that. And it's incredibly expensive to do repeated testings, and then the wind company does testing, and then you have a battle of experts, and these things go on and on and on. The last case here went all the way to the Michigan Appeals Court, and they finally settled. My point is, enforcing a noise ordinance is tricky business, but anybody with a proper measuring wheel can measure a physical distance, and it's beyond dispute. And further, if you're using setbacks to protect property values, a distance of up to 2 miles may be reasonable, but in that case, I think a height limit might be more defensible in court. So here's what we did in my township. We chose 4 times the height of the turbine to non-participating property lines and 1/4 mile to the participating residents. And these larger setbacks could be reduced with a waiver. But the waiver was not given to the developer, to the people. The waiver had to be purchased from the neighboring people. They had to give their consent, rather than the neighboring parcel owner having to get the wind developer's consent to build on their property and so forth. I like a multiple of turbine heights rather than a fixed distance for several reasons, but one is that just in my career, wind turbines have gone from 250 feet to 660, so you can see a 1/4 mile setback might be fine for a 200-foot tall turbine, but it may not be enough at all for a 660-footer. But secondly, if you write a strong ordinance with a high multiple of turbine height, it's very hard for a wind developer to sue you and say you've had exclusionary zoning, because your defense in court would be, well, we've picked a 5 times the height setback limit, and it's true they might only be able to get one 500-foot class turbine in a square mile, but if they build 100-foot tall turbines instead of 500, then they could get many, many, many turbines in. And so that's a strong position to be in court. I think that the setbacks of the non-participant need to be at the property line, or we're awarding an uncompensated nuisance and safety easement to the developer at the non-participant's expense. Equitable wind energy zoning should not forcibly donate unleased property to the neighboring landowner's tenant. The waiver is key. That's what empowers you as residents and neighbors to a wind plant to be able to negotiate on their own behalf with the wind developer. See, if your ordinance sets the setbacks from a neighboring home, the wind developer doesn't need to negotiate with you at all. Your property has no real economic value to him or her because your property's already been donated by your zoning ordinance. But if they need to get an easement from you to build, then your economic negotiating power has just been restored. So now about noise. How loud is too loud and who do you believe? It's my understanding you currently have a 50 decibel noise ordinance. My recommendation is that is not protective enough. But let's ask the World Health Organization. They've studied these things, and I'm getting close to wrapping up here, so don't get too impatient. Up to 30 decibels, that's pretty quiet. No substantial effects on human beings. And this is a nighttime average outside of your home. 30 to 40 decibels in that noise range, you start to see that noise of any type starts to have some effect with body movements, awaking, sleep disturbance. The effects may be pretty modest at those noise levels, but the young or chronically ill and elderly are affected to a greater degree. Now, the World Health Organization says when that nighttime noise limit gets up to 40 to 55 dBA, you see a sharp increase in adverse health effects. Exposed populations have to adapt coping mechanisms, and vulnerable groups are severely affected, and above 55, adverse health effects occur frequently. Now, people often say, well, I know people that live in noisy cities, and I know people that live next to airports. Yeah, that is true, but there's also very solid studies that show those people have a diminished quality of life. Now, why don't we ask an American Wind Energy Association noise expert? Dr. McCunney wrote a paper that concluded that there's 45 decibels would not cause adverse health effects outside your home. 45, not 50. Later, Dr. McCunney participated in a seminar where he made it very clear that if it was his home in the vicinity of a wind farm, he would want the noise levels to be kept below 35, something along those lines, maybe 40. George Hessler is an acoustic consultant. He works for many wind developers, but the state of Minnesota hired him to study community acceptance of wind turbines. And his conclusion was, based on the observed reaction to typical projects in the United States, it would be advisable for any new project to attempt to maintain a mean sound level of 40 dBA or less outside all residents. And even at 40, it would not be completely insignificant, but most people would not have much issue with a 40 decibel noise limit. I agree with that. Now I'm going to bring up another fellow, Dr. Paul Schomer. His credentials are there on the screen. All I can say is this is one of the most credentialed acousticians in the United States, and he is respected around the world. He's an older gentleman, and curiously, Invenergy has hired him several times in the past to observe measurements being taken by Michael Hankard, who is the acoustic consultant working on your project. So Invenergy thought highly enough of this gentleman to oversee one of their other acousticians. He's come around and come a long ways on his position on wind turbine noise issues, and I've already said this. Here are his recommendations in his most recent presentation. For audible noise, public officials should require that the maximum A-weighted sound level of any residence be 39 decibels or lower. And then for very low frequency sound and infrasound, something that the wind industry suggests is non-existent or is not problematic, the Dean of Acousticians in the United States says public officials should require the industry to prove that their new designs will not create adverse effects on people, notably on sleep or those of the type listed on earlier charts. And I can give you the full presentation if you want it. This proof from industry must be provided before any new wind farms are approved. And Vestas, like I said, one of the biggest turbine manufacturers in the world, they recommend that governments supplement relative noise limits with a very low absolute maximum in areas of very low background noise, quiet countryside. Nebraska certainly qualifies as a quiet countryside. That will ensure minimal noise disturbance for turbine neighbors. I would guess that your nighttime noise levels in your county away from population centers is going to be maybe as low as 18 on very quiet nights and probably an average of 20 to 25. So by setting a 50 decibel noise limit, you're giving the turbine operators license to raise your nighttime noise levels from 25 to 50, which is 4, 5, 6 times louder than what it is on a quiet night. What our board did was a compromise. We adopted a 40 decibel nighttime noise limit at non-participating property lines, and then we adopted 45 decibel daytime noise limits. And then for that low frequency noise that Dr. Schomer referenced, they added a 55 decibel limit. These were a compromise with developers' desires and balanced against health, safety, and welfare concerns. And curiously, Lancaster County, Nebraska, you may have seen this ordinance, but this fall they adopted regulations that said from the hours of 7 to 10 during the day, 40 decibels, and at night, 37 decibels. That's strong protection. One thing I did not see in your ordinance is shadow flicker, and I suggest you look up a video on YouTube to see exactly what that means. It sounds pretty benign, but it really can be pretty obnoxious. The good news is the turbine manufacturers now have a software and sensor package that can actually detect flicker events when it's happening, and it will shut the turbine down for the time as the sun moves across the path to protect houses inside the shadow flicker boundary. Now, developers will tell you that shadow flicker runs out to 3,000 or 4,000 feet at worst, but we're measuring shadow flicker over a mile in Mason County, Michigan, and in other places. I would say with this new improved shadow flicker detection equipment, you could probably set a 0 flicker limit. They can easily comply with that. Now let's get to decommissioning. These are turbines in Hawaii. We're routinely told that you don't need a decommissioning bond or anything because the scrap value of the turbines is enough to pay for their decommissioning. Well, if that's the case, these turbines would have been taken down immediately after they went out of service. They are now finally removed, and it turned out the scrap value was not adequate, and it cost several hundreds of thousands of dollars to remove them. So decommissioning matters. I recommend that your county consider a decommissioning bond requirement and let the value of that bond be determined by an independent third-party engineer, and let the municipality pick the engineer and make the wind developer pay for that engineer. Now, wind developers often recommend a financial guarantee instead of a bond. And I'm always leery of that. First of all, a bond is tricky enough. I mean, the bonding companies never go on to pay out if they don't have to. So I would suspect if the turbine developer defaulted and the things are left standing, they're going to fight you like crazy to ever pay out to remove the things. But there's another reason. Terraform is a yield co that's owned by SunEdison, or affiliated with SunEdison, and they recently bought 1,000 megawatts of wind from Invenergy. So my point is, the turbine developer you're working with now may very well change, and in this case, Terraform bought them out. But yet this spring, will Terraform follow SunEdison to bankruptcy? So Terraform, you can search this on the internet. They're making quite a splash, and SunEdison is one of the biggest renewable energy companies in the United States, and they filed for bankruptcy. My point is, if you had financial guarantees from a company and your assumption was they're $1 billion company, they can easily pay to clean this up. Not everything, that's a risky position. You're much better served with a decommissioning bond. Now, I have no knowledge that Terraform has anything to do with your Antelope County project, and that's not my suggestion. But like any other development project, developments routinely change hands. The average lifetime for a developer to own wind turbines is 6 or 7 years, because that's when the PTC and stuff starts to change, the financial things leverage. Now, NextEra tends to never sell them, but Invenergy seems inclined to sell more, and we see turbine projects change hands. Michigan's oldest turbine project's on its 3rd or 4th owner now since 2007. My point is, the people you're negotiating with today very well may not be there in 3 or 4 years. How about property values? If you've had any discussion about property values in your meetings, then this report was brought in by the Berkeley National Lab. And what they use that report to say is that there's no statistical loss, significant loss of property values near wind turbines. But the author of that report is a fellow named Ben Hone. And on a telephone interview, he said, I think one of the things that often happens is that wind developers put our report forward and say, look, property values aren't affected. And that's not what we would say specifically. On the other hand, they have little ground to stand on if they say we won't guarantee that. Well, I think if wind developers are serious that wind turbines have no effect on property values, they would be at no risk at all offering you a property value guarantee. There are 3 studies that do suggest that there's no loss of property values with proximity to wind turbines, but they are funded by the industry. There's a whole bunch of independent studies that show property value losses of 14 to 59% for residences within 1 to 3 miles of wind turbines. So I'm wrapping up now. Most land use changes are pretty benign. Minimum lot sizes, the sign of your ordinance, sign ordinances and so forth. I mean, if you allow a 40 square foot sign in front of the bank instead of a 30, okay, some people might not like it being a little bit bigger, but nobody's really going to be too much harm. But wind turbines are so big that the impacts are disproportionately large, and you have to be incredibly careful. We felt that the change of land use policy was so massive and the impact so profound that they should not occur without consent of essentially all the impacted parties. Two-stage setbacks with a waiver option for both noise and distance required the developer to negotiate with everybody that's impacted. It's fair and equitable and reduces community division. And remember, nobody has ever come before your county commissioners or planning board and said, the light coming through my window is too steady. Could you make it flicker? Nobody's ever come in and said, the nighttime noise level is too quiet. Could you raise it to 55 from 25? And nobody's ever come in and said, my property values are too stable. Could you build some 50-story industrial machines next door to put that value at risk? The bottom line of zoning is this. We were here first. We get to decide. It's basically an inverted cone that they establish over the runway and the flight path, and that's exactly how they regulate these things. So yes, I would be surprised if Nebraska does not also have the ability to do that. And in our township, we adopted protections for 3 or 4 existing grass strips because one wind developer or one of the leaseholders was so aggressive with the neighbor. He says, I'm going to stick this turbine right at the end of your runway because I don't like your opposition to this project. So yeah, you need your community to protect those grass strips if that's something that's of value to you.
Does anyone else have any questions for Kevin? He has some time to think here. We welcome any thoughts or questions or concerns. Again, I know it's a lot to take in, a lot of stuff, a lot of numbers there. And you said your presentation, we can make that available to people then, Kevin?
Yeah, absolutely, without objection, and you can watch my other versions on YouTube.
Okay, thank you.
Okay, well, are you done with me then, Corey?
I think so. I know it's in Michigan. You're probably getting late out there. So
I woke up at 3:30 your time, so yeah, I'm pretty tired. Well, it's a blessing to meet you all, and I hope you guys make wise land use policy decisions out there. I wish you the best.
Okay, thanks a lot. Thank you.
Thanks.
Good evening. I'm Mark Hunziker. I'm a partner in the Baylor Evans law firm. I've spent the last 35 years or so representing developers. And so I have a little bit of that perspective to draw on as I look at your regulations here. Your zoning regulations regulating wind energy systems were clearly drafted by developers. I have a little experience doing that. I've been paid by my clients quite a long time for manipulating and drafting ordinances that are favorable to them. And I can tell that this ordinance has been drafted by wind developers. They do not, in my opinion, adequately protect non-participating property owners. And you've heard a lot of this from Kevin, but the setbacks are clearly wrong. To have setbacks from the tower to the neighboring home is an illusory kind of setback. There are lots of areas around these towers that will not have homes on them, but their development rights will be affected if the current system of reciprocal setbacks is continued. The noise levels are also too high, as Kevin said. They need to be reduced, and they should also be measured at property lines. In my opinion, this application ought to be placed on hold. It should be sent back to the Planning Commission pending a review of your ordinance for the purpose purpose of protecting the health, safety, and welfare of non-participating property owners. The application before the Planning Commission was not complete. The site layout is totally deficient. It does not have specific sites for each turbine, although there are numbers on the map that show there will be turbines in a particular location. Those locations are not fixed. The developer intended, or at least requested, 900 feet of flexibility in any direction for each one of those dots on the maps. If you're looking at those maps, 900 feet would be a huge amount of land. The Planning Commission pulled that back a little bit and recommended that they be given 600 feet of flexibility in the location of those turbines. But a 600-foot radius, if you think about it, is 26 acres. And if you add to that the 2,000-foot setback beyond the edge of that 600-foot radius, you've got a 2,600-foot radius that could potentially be affected by each of the dots on that map, which isn't mapped on, or which is not shown on that map. And each one of those turbines could potentially, with that much flexibility, affect as much as an area that encompasses 487 acres. That, in my opinion, is not a decision based on a plan that is in any way fixed or enforceable. It's really an abrogation of the county's responsibility to protect non-participating landowners. There has been no acoustical analysis submitted with this application. That is a requirement of your ordinance. The acoustical analysis required by the Planning Commission was that it be submitted within 2 years of construction. Now, I suggest to you that based on the illustrations, the photos you saw today of abandoned wind towers not being removed, imagine how easy it will be to require that one be removed if in 2 years after the construction it's discovered that the noise standards of your ordinance are being violated. It's not going to be easy, and they will not give up easily. They will fight all the way to the Supreme Court over these issues. You already have a situation, as I understand it, where there are allegations, or at least complaints, of noise violations on the previous project, and those are not being given up. And in fact, as I understand it, your county allowed the owner of those turbines to go and hire their own expert to determine whether or not they were in violation. That's not my idea of objective measurement of those kinds of standards. The hearing, the other deficiencies include decommissioning. The decommissioning that Kevin talked about. There does need to be a bond provided. The decommissioning plan that was submitted and is coming through with this application proposes that after 15 years of operation, the owners of the project submit proof that they will be able to, there will be funds available to decommission the project once it's no longer operational. I would suggest to you that given the uncertainties of all of the tax credits that make these projects feasible, it could be as little as a year or two after construction that these projects are no longer economically feasible, and the ability to finance the decommissioning would be in doubt. Again, there were other smaller deficiencies in the application, but the point is, the plan and the application that the Planning Commission held a hearing on and made a recommendation on was not a complete application in accordance with the regulations of your county. This application ought to be sent back to the Planning Commission to be completed and to have a new hearing and recommendation prior to coming forward to the county board for a decision. A couple other things about the timing of regulatory changes. Kevin alluded to it, and I have talked about it with him a little bit. I've talked to the county attorney about it, and I intend to submit a memo to him shortly about it. Kevin is right. The law of Nebraska is that a developer does not have a vested right to existing zoning regulations. The only time rights vest are after issuance of the permits and actual construction takes place. So any time prior to that, it is within the prerogative of the county board to make changes, particularly to such things as setbacks, noise limitations, height limitations, and the like. There's been only one case that I'm aware of where in Nebraska where a development was deemed to have acquired vested rights, or at least the county's or the zoning authorities' regulations were deemed to be arbitrary, capricious, and unreasonable. And in that case, the county went in, or the zoning authority went in and rezoned the property after an application had been put in to actually prohibit the use that had been applied for, and it was done in a way which was clearly improper and adversarial, and was deemed to referred to by the Supreme Court as punishing your enemies and rewarding your friends. Clearly inappropriate behavior by the zoning authority in that case, but other cases where things like setbacks or height limitations and the like have been changed, they are routinely upheld, and the county's zoning authority is one which is accorded broad discretion in litigation over the validity of regulations, zoning regulations in particular. Kevin alluded to it as well. There is a presumption of validity that is engaged by every court that hears those cases, and so to the extent that the county is acting to preserve and protect the public health, safety, and welfare, it is well within its right to do that at any time prior to actual construction taking place under a permit. So I guess I want to just say a couple of things about these about the hearing that's coming up on Tuesday. Your county officials are feeling some pressure primarily because the dollar signs are big. This developer is waving a lot of money out there saying we're going to pay a lot of taxes, and every county official in the state of Nebraska and probably everywhere else has heard 100 times, if they've heard it once, property taxes are too high, and it's important that we do something to relieve the property tax burdens on everybody. The fact of the matter is, whatever property taxes are paid are going to be coming out of your pocket.
There's 4 towers maybe that are in line that create the noise. They came on a Tuesday, put the microphones up, and on Thursday, one of the towers was shut down. Big crane showed up, destroyed 3 bridges getting there, and took the tower down. And it was down for 10 days while they were testing. And the other 2 towers, 1 and 2 closest to me, were shut off and on during that time period. So that's an accurate test.
How do you feel about the impact of the noise on your house? Can you describe it?
This has been a real problem ever since they've happened. The towers are like 1,300 feet away. This was the first project where they were allowed to be 1,000 feet. And the noise is enough to drive you crazy. Some days you don't hear it, some days you hear it tremendously. Enough that we don't dare open windows anymore. The other night we tried opening the windows and closed. Now granted, we've got a bigger setback since then, and I think it has helped. But as far as getting an accurate noise study, I think it's impossible, because they control it.
I think that also reiterates what Kevin was saying about using setbacks rather than decibel levels as a guide, because they are very hard to measure consistently because of changes in weather, changes in wind direction, and all that. It is very hard to get a consistent reading, and I think it would be even harder to get Invenergy or any other developer to agree that they're in violation. They are not going to voluntarily shut off or take down one of those towers.
Do you know of any other counties that have it at the property line, or at the residence of the property line?
Actually, I'm trying to remember exactly what Lancaster County had previously. Lancaster County recently went through a revision of its regulations, and there was a major argument about where the setbacks would be measured from and what the decibel levels would be. Lancaster County actually originally had decibel levels that were lower than their 40 and 35. They went up to 40 and 35. The wind developer there was trying to get up to in that 50 range. I'm not exactly sure what other counties are doing. I believe Gage County recently adopted the same standard that Lancaster has. And we have setbacks in Lancaster County that are measured from property lines, not to the next house. And it was for all the same reasons. I mean, I represented a client in that matter where they had gone out and bought a large acreage, a large piece of land out in Lancaster County for his son to build a house on. And he would have been within the radius of those setbacks and the noise contours had they been able to measure them onto other people's property rather than from the setback. And it was a big concern to him because it was a major investment that was essentially going to turn to zero for his purpose. Yes, ma'am.
Will you please address stray current? Is it real? The current or the water underground?
That's a question that I'm not sure I'm qualified to answer. I don't know much about that. I've read just a little bit, and I would hesitate to even try to give you a guess. But there's a lot of information out there about. I mean, if you go do some Google searches on wind energy projects, you'll find a lot of information. Yes, sir.
If the windmill did get put up, is there a way that we can prevent them from trying to get their taxes lowered?
Is there a way to prevent them
You know,
from?
the company's got way more money than our county. So, where Kevin was talking about them trying to renegotiate what they're paying in taxes, is there a way that we can do that prior to giving them?
Is there a way that you can prevent them from protesting the tax, the assessments? The short answer is no. I think Nebraska's system for taxing these things is a little bit different from some. It's a more of a centrally assessed flat rate that is determined statewide as opposed to the county level. So the assessor's not going out there and putting a value on each tower or each project separately. There's a kind of a standard rate that's based on the capacity of each tower. And so I'm not exactly sure of that because I'm not a tax expert, but I think that's generally the scheme, and I think it would be harder to get that lowered probably than it is in some places.
Well, that's just negotiated with the legislature, 3,815.
Well, yeah, I mean, obviously, there's potential that the legislature could change it, and who knows which lobbyist is successful. Okay. Yes, sir.
Is the reason why they want to put so many turbines in Antelope County is because our regulations are so easy for it?
I get up and turn the TV on just because I can't sleep. It's just unbearable. And that gets really frustrating. And as far as being outside at times through the winter, it's like living right at the airport. That noise is really loud. And I also deal with a low audible hum that gets to be, it's just like vibration. It's pretty tough.
Do you know how far you are from them?
I have 3 of them within a half mile. One's just a little over a quarter mile, and 3 of them within a half mile. Now, there's also a buried power line that feeds from these lines, and that's just a quarter mile away. And I think that has a little something to do with the vibration from that line. You know, something I can do. I feel that way.
Thank you, and that brings up another point that I think your regulations ought to address, but they don't. And that is what has happened, at least in prior projects, is that the developer will find a sweet spot where a cluster of towers can be placed within an acceptable or outside the setback distance from the home or other property, and they'll cluster 2 or 3, as you've got, within a half mile or so of single residence. It seems to me that it would be appropriate to say that if you're going to have a setback of 2,000 feet or whatever the number is, there ought not to be more than 1 within that distance from an existing home in particular. Yes, ma'am.
Yeah, I live close to the county line, and, I live close to the Boone County line also when, at Infinity put, 5 across the section, just into less than a mile, half a mile to a little bit more than half a mile. And a 6th one right next to it, and 2 across the road, which made 8. And then straight with another mile straight to west of me is 4. They keep you up a long time. They do wake you up. They, you know, every night my husband died, but he was a very sound sleeper, and the very first towers that turned on were the ones that were over a mile away to a mile and a half. And those 4 towers had him up all night looking out the window because he thought somebody was down at his bedside. And I was up the rest of the night looking and thinking, what is that noise? It does at a lot of times sound like you would by a solid airport where the planes never stop. So the noise level is unbearable.
Thank you for that. Yes, ma'am.
I think I can talk about it.
Okay.
My question is, could we regulate density of these? Because it sounds like the problem comes with a multiple set of wind towers that are vibrating against each other. You know, those sound waves. And so maybe spreading them out might eliminate some of that. Still have a setback.
Sure, I think that's probably a very good suggestion. Perhaps a distance requirement between towers could be worked out, as well as a limitation on the number within a certain distance of an existing home. Okay. Anyone else? One more.
What's the rules with FFA as far as lighting these towers, having lights on them? Are they all supposed to be lit?
I am going to have to say I don't know the answer to that very well. I've seen some of these farms. The one that just is seared into my brain is in California, near Palm Springs, where you drive by seen, and they are all lit. And as Kevin mentioned, they are all flashing simultaneously.
Is it anything over a certain height supposed to be lit?
There is a height, and I'm not, there's a height beyond which they have to have strobes, and some below a certain height, they can just be a solid red light. Yes, sir.
I asked Neligh Energy that question. They said they submit their plan to FFA or whoever it is, and they determine which ones they want to light. Which, I'm like Larry, I think everyone should be lit. Because there's 4 of them next to me, and 3 of them are lit, and the 4th one isn't. So if you're up there in an airplane, you're gonna aim where there's no light. And you're gonna crash right into that middle one.
Good point. I don't know what those regs are.
That's what I would.
Yeah. Yes, ma'am.
On the people who are having difficulty with their noise levels, what is written into their plan for that decibel level to be? What is it?
What's written into the application?
Yeah, what's in that regulation?
Well, I wish I could tell you that. The regulation that you have in Antelope County allows for a noise level of 50 decibels at the house of any adjoining property. So not at the property line, but at wherever your house is.
I understand that.
And so it's a 50 decibel limit, and there's no noise contour study that has been submitted with this application, which I think it makes it an incomplete application. I don't know how you could.
Do an application for the towers there, and there's not the noise level in decibels addressed there? Are we looking at I'm just asking, but are we looking at these people having 70 decibel noise level as the limitation or the low level?
No.
Where are we at with that?
The regulation as it stands today is 50 decibels.
Where?
At the house, in the whole county.
Okay, and the ones that are in Boone County that she's talking about, what is theirs?
50.
It's all 50.
Yeah.
Okay. Just
Which-
so we're comparing apples to apples.
Yes.
The question is, have they been independently studied to make sure they are under 50?
No.
No,
No.
not till now.
Well, and that wasn't independent, that was a consultant hired by Invenergy.
Yeah. So it's still not.
No.
No.
So they might be running 70, she might be right.
Once they're up, they're up.
Once they're up, they're hard to get down, that's for sure.
Not really.
They tell me they can turn them down.
Okay.
Which should have been my first clue that this wasn't gonna be a good test.
Yes, good point. Okay, well, thank you all for coming. I'm getting the signal here that we kind of need to wrap this up. But again, there's more information over here that you can pick up on your way out. The public hearing is Tuesday at 9:15 in the morning. So if you can get there, please come. No, actually, get here. The hearing is here at 9:15 Tuesday morning.
Well, yeah, thank you for everybody that came out, really appreciate it. Now, if any of you have grabbed, I don't know for sure if you know what that map is. If you didn't get one, please pick one up. I'll just explain it real quick. That's a map of the upstream project. The purple circles are residences that are not participating, or purple are participating residences that would have a 1,500-foot setback from a tower. The pink circles are non-participating landowners. Those people will have a 2,000-foot setback. So no tower can be built within 2,000 foot of that house. The yellow circles, if you look inside that yellow circle, there's a dot. That is the location of every tower in the proposed project, the 168 towers.
Plus or minus 600 feet.
Yes, plus or minus 600 feet. But the yellow circle is a 2,000-foot circle, because once a tower is constructed, the tower will have a 2,000-foot setback. Just like a cattle feed lot or a home would have, that's not participating. So the purpose of that is to show folks how it can limit our expansion in this area, whether it be at homes or whatever that could possibly be built. Nobody knows in 10 years what opportunities there may be. So that is the purpose of that. So if you have one now, maybe that'll help, or else grab one on the way out. Thank you very much for coming.